Welcome to Chapter 7 of Law in Australian Society, which is about Indigenous peoples and the law. In this chapter, you'll learn about what justice and sovereignty would mean for Australia's First Peoples, the settlement of Australia by Britain and the doctrine of terra nullius, the High Court's landmark Mabo decision, which overturned terra nullius and recognised native title, and the lack of recognition of Indigenous people in the Constitution. If you think back to Chapter 5 and different meanings of justice, you know that justice can mean lots of different things. So what would justice mean for Australia's Indigenous population? Well, Australia's Indigenous communities face systemic disadvantage compared to the population as a whole. This includes lower life expectancy, lower rates of literacy and numeracy, and higher rates of unemployment. The Australian government's Close the Gap campaign aims to redress these inequalities, but there's much more work to do. And a major issue is the significantly higher rates of Indigenous imprisonment. So justice for Australia's Indigenous population would mean, firstly, reducing these inequalities and improving outcomes and opportunities for the Indigenous population. But justice can also mean something more. If you think back to the apology in 2008 by then Prime Minister Keiran Hardy, and this is talked about in the textbook, apology can also mean that the government recognises the wrongs that have been done to Indigenous peoples in the past and a commitment to fixing those problems for the future. Sovereignty is another important concept that can help you understand the position of Indigenous peoples in Australian society and our legal system in particular. So traditionally, sovereignty means ultimate legal and political authority over a given territory. So Australia is a sovereign state. The United Kingdom is a sovereign state. However, the High Court has consistently held that Indigenous sovereignty cannot be recognised under Australian law because this would impact on the sovereignty of the Australian government. Sovereignty is seen as quite a singular thing. It cannot be split or divided between people. You either have sovereignty or you don't. However, sovereignty can mean many other things to Indigenous people that's not just in line with this traditional meaning. So it can include the spiritual tie to the land and the ability for Indigenous peoples to determine their own future. In order to understand the position of Indigenous peoples under Australian law, we need to trace this back to when Australia was settled and then later at Federation. So the High Court has held that Australia was settled by Britain rather than being conquered or ceded by an existing population, and the distinction between these is discussed in the book. This is significant because it fails to recognise that Indigenous people have lived on our land for at least 65,000 years. Terra nullius, which means land unoccupied or land belonging to no one, was a legal fiction that allowed the doctrine of settlement to apply in Australia even though Indigenous people were living there. It was based on the discriminatory idea that Indigenous people were so low on the scale of social organisation, so primitive, that they should not even be considered people at all. Mabo in Queensland, number 2, which is just known as Mabo, is probably the High Court's most famous decision. In it, the High Court said that terra nullius no longer applied in Australia and that government control over the land remained subject to valid native title claims. Native title is a property right that Indigenous groups can claim by establishing in court that they maintain their traditional customs and practices in an area of land. This made significant gains in achieving justice for Indigenous peoples. However, it's also worth considering some of the limitations of the decision. Importantly, Mabo did not overturn the doctrine of settlement or recognise Indigenous sovereignty. In order to keep moving forward and achieve justice for Indigenous peoples in Australia, constitutional recognition is very important. So this is the idea that Indigenous people should be recognised in some way according to some model in our Constitution. Currently, and following the 1967 referendum, the Constitution makes no reference whatsoever to Indigenous peoples. Over time, there have been various proposals to achieve constitutional recognition. Recently, the Referendum Council published the Uluru Statement, which included recommendations such as establishing a First Nations voice to Parliament and a Makarrata Commission, which would rely on a similar concept to restorative justice. These proposals are set out in more detail in the book, and part of the point of this chapter is to show you the different ways that constitutional recognition of Indigenous peoples could be achieved. So to reiterate the key points from this chapter, Indigenous Australians face systemic injustice. This stems from the colonisation of Australia by Britain and the forceful removal of Indigenous children from their families in the stolen generations. Achieving justice for Indigenous peoples would involve remedying these inequalities. In Mabo, the High Court recognised native title and overturned terra nullius, a principle which said that Australia was settled by Britain because it was owned by no one. The judgment was very significant for those reasons, but it also did not recognise Indigenous sovereignty and it did not overturn the doctrine of settlement. Australia's constitution currently makes no reference whatsoever to Indigenous peoples. An important question for legal policy is how Indigenous people can best be recognised in the constitution and how this can be achieved. Some discussion questions for this chapter. What would justice mean for Indigenous peoples and how could this be achieved? How do Indigenous ideas of sovereignty differ from those relied upon by the High Court? What were the major benefits of the Mabo decision and what were some of its limitations? And how can an Indigenous group make a successful claim to native title? Which sections of the Constitution refer to Indigenous people? What models for constitutional reform were proposed by the expert panel and more recently the Referendum Council? And which model do you think would better achieve constitutional recognition of Indigenous people?